Good afternoon, Your Honor. My name is Pedram Surgali, and I will be representing the accused in today's proceeding. The defense is seeking an order pursuant to Section 590AA2E of the Code to render Mr. Smith's admission in his police interview inadmissible, or alternatively, that Your Honor should exercise the court discretion to exclude admissions on either fairness or public policy grounds. Your Honor, the defense submits that the court should exclude Mr. Smith's admission in his police interview. Based on the arguments that his admissions were not made voluntarily, which is to say that his will was not overwrought. Defense will argue that the conduct Detective Walsh made when interviewing Mr. Smith was such a reprehensible nature as to induce Mr. Smith into making several admissions. As explained in the case of McDermott by Justice Dixon, confessional statements made out of court are inadmissible unless it is shown to be made voluntarily by the defendant, and that their will was not overbrought in McDermott. Justice Dixon held that it was a definite rule of common law that a confessional statement preceded by inducements from a person of authority cannot be voluntarily. Inducement, as explained in the Crown TOEFL hour, in either a threat of detriment or a promise of material benefit offered by person in authority to an accused person. Police officers have been recognized in McDermott to be persons of authority. As also explained in another case of Crown versus Plotsky, the question that Your Honor must consider is how would have Mr. Smith have interpreted what was said by Detective Walsh during questioning. Now, as was the case in Crown and Zavikas, inducement may occur if a prospective advantage is raised by the accused and then encouraged by the person in authority. According to Section 10 of the Criminal Law Amendments Act, provides that any confessional arising from inducement by either a threat or promise from someone in authority cannot be tendered into evidence, unless the Crown can prove that Mr. Smith's will was not overborne. As it was considered in both Jackson and the Queen case, and the Crown and the Parker, the court must consider Mr. Smith's psychological and physical health when assessing whether he had the capacity to resist any improper pressure from persons of authority. As the case explains that Mr. Smith was not in a correct mood and he had an anxiety. Mr. Smith's anxiety, as well as his physical and mental exhaustion, was psychological and physical impairment that preceded Detective Walsh's statement to entice Mr. Smith was a good feat, followed up with the representation that the feat would be his last for a long time due to being held on remand, and that he would try to ensure Mr. Smith had a sleep in the lockup if the interview completed straight away. Furthermore, Detective Walsh's efforts to get Mr. Smith's by the detective. Your Honor, it's clear from our submission that Mr. Smith's confessions to police during his interview pre-trial were not made voluntarily, but were in fact under inducement from Detective Walsh and should therefore be rendered inadmissible. Your Honor, defense also submits that if the court was to rule admissions admissible, they nevertheless should be excluded. Your Honor, discretion on grounds of unfairness as outlined in Christie's case, Your Honor has the discretion to exclude admissible evidence tendered by the prosecution if Your Honor deems that evidence is so deficient in its probated value. It would be a danger to the jury to hear it. As Lord Moulton explains in Christie, through evidence may be admissible, it should not be pressed because its probative value would be put out of proportion to its true evidentiary value. The Christie doctrine has since been adopted and expanded upon in the case of Hassler. In a recent case, their honors in Playford refused an application to exclude confessions on unfairness ground. Their honor ruled that even though the impugned conduct on police officers in not putting the applicant solicitor in touch with him after they were told one had been retained for the defendant, their honors were satisfied on the balance that this would not have awayed the applicant from confessing to police, as it was established that the defendant had propensity to confess prior to receiving any legal advice. Now, whilst there are similar facts in this case, Detective Wash did not inform Mr. Smith that a solicitor had been retained to represent him after the detective was made aware of this fact. As compared to Playford, in the present case, Mr. Smith did not show any propensity to confess, which is further strengthened by the fact that confessions were made following inducement from Detective Wash, as defense he submitted previously. Your Honor, it is clear that the police conduct withholding from Mr. Smith the information that the solicitor had been retained from him is sufficient ground for the court to exercise its discretion power to exclude Mr. Smith's confessions on unfairness grounds. Finally, Your Honor, defense also submits that even in the event of admissibility, Mr. Smith's confessions, they should nevertheless be excluded in Your Honor's discretion on public policy. The court also must consider the instances as elaborated in the Bunning case. Ensuring fairness and protecting rights is incompatible with the behavior of Detective Wash in emitting key information that would enable the member of the public to exercise those rights, and ensuring fairness by failing to inform Mr. Smith that he had legal representation. Detective Wash has fallen well below the bar necessary to maintain community trust. In conclusion, the order we are seeking as the evidence to exclude on the ground that admissions were not voluntarily, and the court must exercise its discretion power because Mr. Smith had some psychological issue while being interviewed by Mr. Walsh. Thank you.